And we're back, and I was literally just giving time for Nina to throw a million questions. All right, now that we got Nina's questions, we can start the class. All right, so we're gonna go chats. So let's start with the first question. First question from Nina is, what if a divorce lawyer is regularly asked to sell homes? Would they need a license then, or they still don't? So if an attorney is in the normal operations of the law, like they're helping somebody through the divorce case to sell their home, they don't need a license. If they go outside of that particular deal where they're handling somebody's divorce, then yes, they need a license. So while conducting business as a lawyer for the husband and the wife that are about to get divorced, and if they ask them to assist in a transaction while performing the law, right, then no need for a license, right? But if they like it and they go like, oh, I like real estate, so let me find more properties for buyers or sellers, then they're not excused of a license. They need to have one. Agents have access to expired listings on the MLS, and the answer is yes. In fact, that's one of the things that we usually train newbies is going after expired listings. So they're the low-hanging fruit. They need help. Unfortunately, they were not serviced at the time that they needed during the 6 months period. So it's a great opportunity for you to show that whether to say that you're new and you're full of spunk and you want to get this done and I'm going to do everything for you versus those seasoned realtors that just, you're just another house, right? So that's sometimes the opportunity that you have as a new agent. So we go after the expired listings on the MLS. One of the strategies. Yeah. All right, how can a home equity loan be considered a second mortgage but not a construction loan? What do you mean? There's a construction loan that it could be a second mortgage, yeah. It's just how it's called construction loan. It's for constructions. So here, before you disappear, let me explain something. There's what makes it a second mortgage? What makes things a second mortgage? It's very simple. I purchased the house. This is your first mortgage because there's nothing else there. It's a first mortgage. Could the first mortgage be, for instance, an FHA 203B, First Time Home Buyers Program? Yes. Oh, I'm sorry, I'm not showing you. All right, sorry. So you have the time of purchase. That's the first mortgage. Could that first mortgage be an FHA 203B, the purchase? Yes. Could it be conventional? Yes. Could it be a VA? Yes. Could it be an FHA 203K for construction? Yes. So this loan is a construction loan on the first mortgage. A conventional loan could be a construction loan on the first mortgage. A VA loan could be for construction and be a first mortgage. What makes it a second mortgage, let me erase all these. What makes it a second mortgage is that you purchased in 2001, and then in 2003, you did a refi. And the refi could be in different number of ways. A refi could be, we got a brand new loan and we erased this one. So it's a new mortgage. Right? It could be that. Or, going back, it could be an additional mortgage. And when it's an additional mortgage, the second mortgage that's listed. Now, this second mortgage could be what we call a cash out refi. It could be the HELOC, right? And either one of these, cash out refi or the HELOC, could be for construction, but it could also be an actual construction loan. The only thing is, most of the times, and that's what I mentioned in the previous chapter, in the previous video, most of the times the construction company says, wait a minute, we're going to be second? That's high risk. We want to be first. So what will happen sometimes, well, most of the times, the construction company, depending on the amounts, they'll say no, they will not finance the construction because there's a high risk of you not paying. And if you don't pay, who gets priority? As we just went over it the other day, right? Who gets priority? Well, whoever recorded first. So in the event of foreclosure, first mortgage will get paid first. If there's any money left, then second mortgage will get it. So can a first mortgage be a construction loan? Yes. Can a second mortgage be a construction loan? Yes. Right? So that's depends on the purpose. So these are purpose-driven loans, whether on the first or second mortgage. All right, back to the questions. Was that good, Nina? All right. Now, next question was, how does a buyer sign up for an assumable loan? So there's no applications. There's you don't go out there and say, hey, does anybody have an assumable loan? I want to take over. No. But the person that has a loan and wants to get out of it could advertise. Like, for instance, this happens a lot in cars, right? If you have a car, you have a lease. Hey, listen, I only have 10 payments left on this lease. Does anybody want to take over? And we start advertising that, right? If it's financing, I only have a year left on this financing. Does anybody want to take over? So the seller advertises, not the buyer. Now, what the buyer will have to do is most likely, because it's an assumption of a loan, that means you're taking over a loan. We need to notify the bank, hey, it's now me, it's no longer him. So when we do that, we will fill out an application, right, with basic information, again, as if you're trying to do a pre-approval, because the bank needs to know that you are capable of taking over that loan. All right, so we don't go and sign up for, hey, does anybody have it? No, usually it's advertised to you, okay? So here, let me address this. You're talking about the construction loan, okay, right? I'm not looking at the actual question, but traditional, a HELOC is a second only, right? So maybe you need to understand what the way the questions are formulated. Most questions are looking for what is immediate thing, right? So a HELOC is always a second one. A construction, as I just showed you, could be a first mortgage, could be a second mortgage. So if they're saying what is an example of what is considered out of these or all of these except whatever, something like that, then immediately a home equity loan or a home equity line of credit, those are based on the equity that you build over time. So immediately those are considered second mortgages, right? A construction loan could be either or. So maybe that's what I'm not looking at the question right now in detail, but maybe that's what the question is. So remember, home equity loans or home equity lines of credit are always second. They're always something that came after you purchased, okay? Why can't licensed and certified residential appraisers appraise residential properties over 1 million? Different animal. So you need to have enough experience in appraising to then go appraise properties that they're random, right? There are not too many out there. It's not like a 1 to 4 family home that you can find everywhere, right? So when you find $1 million or more, which this is changing, by the way, $1 million is becoming the new norm. Like anybody wants to buy a house nowadays, it's like $500,000, right? $750,000, and that's just a regular home, right? So that is changing. But yes, for appraisers, for the appraiser profession, unfortunately, they do it in stages. So they scale you up as you start as an apprentice. You do residential, then you get certified, then you get licensed or license certified, whatever. And it keeps on going up. Then being a general appraiser, where you can just appraise whatever you want, right? But you have to have years of experience in order to get to these type of properties. Again, because there's not many comps. Until not too long ago, you wouldn't find $1 million homes everywhere, right? You wouldn't. Now you blink your eyes, you look here at the middle of Newark where I'm at, and there's a listing for $1 million, right? And it's Newark. You see what I'm saying? So this might change soon, what the requirements are to become a general appraiser. Can they be subordinated to be first too, or no? What are you talking about, the home equity loans? The home equity loans, if they could be subordinated to be first? Is that what you're asking? Can't see if you're answering. Looks like you froze. Anyway, so, okay, yes. All right, so for a loan to be subordinated, there has to be a reason. There has to be a benefit. A cash out or a line of credit, there's no benefits to the first mortgage. Oh, Zoom kicked you out. That's what I assumed. You froze on the screen for a second. So, as I was saying, for subordination to exist where first mortgage says, hey, I don't mind being second in the event of foreclosure, and second mortgage saying, yeah, I want to be first in the event of foreclosure, there has to be a reason. People have to accept it. Like, why would I say, Nina, to you, right? Why would I say, look, I've been here for the longest time, but it's okay, you can be first. Why would I say that, right? Now, if I'm trying to be courteous, that's the type of person that I am, that's great. But when it involves money, financial liens against the property, there's no cordiality. There's no like, sure, you're the new kid on the block. Come on, take over. No, we don't have that. So there has to be a strong enough reason for me to step down in the event of foreclosure and allow you to step up in the event of foreclosure. And that's what construction, so going back to the whole construction thing, that's where construction loans come in. Construction loans will improve the value of the property, usually, to the point where if we get foreclosed on, right, you get paid, but I get paid. So I don't mind being second because you built in your loan built enough value, right? Built enough value that both of us get paid in the event of foreclosure. That's what it is. A home equity loan, home equity line of credit, might not. So again, when we do the application for home equity loans, cash outs, right? And when we do applications for lines of credit, they ask you, what's the purpose of this? And usually everybody says it's for construction, renovation, whatever, and then they go on vacation. But the point is, your application is for that, where a construction loan, it's clearly for construction and it will be distributed in stages according to the construction. It's just that the second mortgage says I need to be first just to secure my part in case you default. That's pretty much what it is. Okay, so home equity loans usually no, they don't have the same rates. All right, that was it, Nina. Just like 4 or 5 questions. I'm surprised. Usually spend like the first 3 hours just answering your questions. All right, guys. So we already started late, and I apologize for that. As most of you know, Mr. Vadura and Mr. Gardner do not know yet. But unfortunately, I have a back injury, and sometimes it is very difficult for me to even be able to get on the car and drive, or even get out of bed sometimes. So that's why the delay. But we're here, going to push through. We got 2.5 hours, and if you guys are with me, we either complete still today or roll it into tomorrow, because tomorrow is just one chapter. It's math. Okay, so we'll see how it plays. Now, I know, Mr. Gardner, you sign up for the evening class. You're just checking out the morning, seeing what happens. Okay, and Ahmed, come on, what happened yesterday? I was waiting for you. I thought you were going to jump into the evening class. Oh, you're being rocked? You're being rocked, or are you taking care of a baby? Oh, it's the Quiznos sandwiches. That's what it is. You're holding on to Quiznos sandwiches. All right, cool. My baby was playing Spider Girl all over the place. Gotcha. That's a good excuse. All right, guys. So, New Jersey housing regulations. We're going to talk about fair housing laws, which is like the main thing in this chapter, which is discrimination. Every time you see fair housing. Now, we already talked about fair housing in a different chapter in the national portion of the book, which both of you in the evening class will have that once we get to that chapter. And then this is the final week for the morning class, obviously, so we're using the New Jersey portion more as a review than anything else. And then pointing out a few things that are specific to the state of New Jersey. So, again, every time you see fair housing means we cannot discriminate. We got to be fair to everybody. And then we'll talk about leases again. So, fair housing. In the national portion, we talked about the federal law. In this portion, we're going to talk about state law. Very similar to federal, just stronger. New Jersey became one of the strongest laws when it comes to fair housing. So they created their own law against discrimination. And the Attorney General even created a memorandum that must be distributed with every single listing. You guys remember that, right? So if you guys remember, in the federal portion, we had 1866. And does anybody remember what 1866 was all about, the Civil Rights Act of 1866? And I told you to just focus on 1866. Let me know in the chat what you guys remember about this. 1866 was regarding what? Drop it in the chat. 1866, what was it? If anybody's watching on YouTube, let me know as well. Boom. Race and color. Yes. So, 1866, Civil Rights Act was passed that finally, after 1,866 years, Ani Domini, right? So you're talking about from year zero, forget the previous years. But finally, 1,866 years later, we say, wait a minute, there's discrimination in this world. We got to prevent discrimination, right? Nobody realized that before. So in 1866, they said, hey, can't discriminate against race, period, right? And it became the strongest one of all because in 1968, if you guys remember, so a quick recap of federal and then we go back to state. In 1968, if you guys remember, so 102 years later, they added more protected classes. So we went from race and color to now have also religion and national origin as protected classes. We cannot discriminate against different religions or against where they came from, where people come from, right? So that was 1968, 102 years later. But 102 years later, with these amendments, they also added exceptions. Of course, because lawmakers say, right, thou shalt not discriminate, but if thou does it this way, it's okay. So they created exemptions where it allows you to discriminate. If you guys remember, one of them was if it's owner-occupied, 1 to 4 family, you can discriminate against the 3 other units and who's going to live in it, right? If you guys remember, religious-based organizations purchasing homes for the members of that particular group, not for the whole religion, but for members of that particular group, or private clubs, if they buy houses that are intended for the members, then they can discriminate based on membership, right? So these are the exemptions. You're not a member of our club. It's not about your race. It's not about your color. It's not about your religion, national origin, whatever. You're just not a member of the New Direction Club. That's it. These houses are intended for the members only, okay? So those are exemptions that were added in 1968. Now, in 1968, we also had the second biggest movement of this amendment, which was the Jones versus Mayer. Now, Jones, an African-American, if you guys remember, sued Alfred H. Mayer Company because Alfred H. Mayo Company refused to sell him a home in St. Louis County, Missouri, just because of race, right? So in the court decision, they said, the judge says, wait a minute, the laws against discrimination started in 1866 because of this exact thing. We cannot use the exemptions that were created in 1968 to forget what happened in 1866. So Jones versus Mayer became the case known as the case that solidified, the case that established 1866 as a foundational stone that cannot be removed at all, right? So where race is involved since 1968, right? Where race is involved, there's no exemptions, there's no exceptions. You cannot discriminate. And guess what? When we come to New Jersey law will say the same thing. New Jersey law is very clear about that. New Jersey also has exemptions, but they're very clear about where race is involved, no exceptions whatsoever. All right? So in 1945, so that was just a quick recap of federal, but in 1945, coming back to Jersey, New Jersey enacted the New Jersey law against discrimination. Now, it was mainly created for employment, right? But then it extended, just like everything else, it extended to all different fields, for credit, for fair housing, right? So it extended to all different fields. One of the things that New Jersey did that federal does not have is say, well, federal says on the sale or rental of residential property, we cannot discriminate against race, color, religion, national origin, and so on, but on the sale or rental of residential. Now, New Jersey says, what do you mean just residential? No, all real property. I don't care if it's residential, if it's commercial, if it's industrial, it doesn't matter what it is. You cannot discriminate, period. That's what Jersey said. You guys understand? In fact, New Jersey also said not only all real property, but also, let me skip here. The only exception applies for, and we'll go back in a second. The only exception applies for rentals. Notice that I have this in green. Okay? Rentals. So in the federal law, and we need to know the difference between these two, because in federal law, when you're selling your house, you could say, oh, no, not you, stay away. No, not you, next. Right? You can say that according to federal law. But New Jersey says, if you're renting, maybe you can discriminate. We'll put some exemptions here. But if you're selling, you're getting out of there. Why are you discriminating against who buys? You're getting out. So you know what? Get out. Simple. Right? So that's what New Jersey did. So when you're selling any type of real estate, any type of property, when you're selling in New Jersey, you cannot discriminate at all. Period. If it's rentals, we'll go back to them in a second. Now, I just want to show you real quick what Jersey did. You guys already know race, creed, religion, national origin. These are basics. This was the federal, right? In 1988, they added gender and sex in the federal law, and Jersey says, yep, we agree with that. But then New Jersey added a few more things, like gender identity or expression, right? Whatever you feel like you want to be, right? That's what you feel like you are. We cannot discriminate against that. Also, we cannot discriminate against somebody being single or somebody being married, somebody with children. You guys know that also from 1988. So we cannot discriminate based on that. Another thing that Jersey added and made it stronger as well is affectional or sexual orientation. Shouldn't matter who I like, I'm qualified to buy, period. You're discriminating because I'm gay or because I'm not, or because I should be, or because I should not. Whatever it is that goes through your mind, that's great. That's your problem. I'm qualified to buy. That's all I'm saying. It shouldn't matter what I like or I don't like. I got the money. I got the credit. Let's do this. Simple, right? Familial status, we talked about this. Familial status means family with children. right? Under 18, obviously. Family with children. Another thing, this was in 1974, they added another, I'm sorry, not 1974, it was gender, 1988. They added this in the federal law, which is people with disabilities, including AIDS. So people with disabilities, including AIDS, cannot be discriminated against either. Jersey also said, especially for rentals, I don't care where your money comes from as long as it's lawful. And this is mainly to protect people that are on welfare and they have Section 8 funds or welfare funds, right? Or they apply for purchases. If you guys remember, we talked about it in finance in chapter 17, that there are programs out there to help people that are low, moderate income, right? So I don't care personally. Again, it always comes back to money. Are you qualified? I don't care what type of qualification you have. Unless I excluded immediately from my listing, I said cash only, right? I said conventional only. Unless I excluded immediately in the listing, then I'm not discriminating against one person in particular. I'm just saying this is the type of buyer I want financially. You understand? So I'm not discriminating. The lawful source of income is just the type of loan or the type of financeability that this person has. Simple. And a liability for military service. So if you leave for military service, you cannot lose your home or say, no, we're not renting to you because today you're here, tomorrow you might not. No. All right, so this was New Jersey. As you guys can tell, it has, those of you that did federal law, right? New Jersey has way more than federal. Now again, let's go back to exceptions. You guys know that based on federal law, 1988 federal law, they added familial status. So again, discrimination is prohibited against families with children. So if you have minors under 18 in your household and you say, hey, I want to rent this unit, nobody can say no to you. Nobody can say no to you, except, here's the exception. Sorry. If you guys remember, housing for 55 plus, or strictly for 62 or older, or government retirement homes. So these entities, because they are, again, let's think about it as membership. They were created with the intention of being for seniors. So I'm not discriminating you because you have family, right, and you have children. I just said, again, if we're upfront about it, literally, everything comes back to disclosure. If I'm being upfront about it and I say, hey, listen, this is what it's intended for. It's for seniors, right? And we have that, what I told you guys, the HOPA, right? HOPA is Housing for Older Persons Act, right? And that's where the exemption is. It was intended for seniors, right? So if it's intended for seniors, can I say no children? Absolutely, right? So these are the exceptions. Additional exceptions include rental of rooms or apartments or flats. They may be restricted to members of one sex in certain kinds of housing. Now, what does it mean, members of one sex? Does it mean that our sexual orientation is for that one sex and that we can rent it just to them? No. Think about it. If I'm single and I have my apartment, right, and I want to rent a room, if it's allowed in whatever town you are, or if I have a duplex, right, it's a two-family side by side, and I say, hey, the people that live next door has to be men, or at least a family that's already built, right? I don't want women owned. Can I restrict, right? Because it's owner occupied, I can, but if it wasn't, I could also, so owner occupied, because I'll explain down here, but if it wasn't, I can also always restrict to members of one sex. I'm a man, I want to rent the next door to be a man as well. So if it's a woman, and that will make more sense as far as protection, right? If it's a woman, they want to rent to another woman, that will be okay. And I'm telling you this because there might be a question in the state exam, where in the school or the state exam, where the owner Mary, the owner of a duplex, wants to rent the other side of her duplex and wants to rent it to a woman only. That's her advertisement. Which laws does this violate? The answer is none. It does not violate any law because it is allowed in certain kinds of housing. So in this case, again, it's like a protection, right? The next one is religious organizations. Like I said before, in federal, we're saying it again in state. If it's for religious organizations, let's say this is the Christian Church of Newark, right? And it's only for the members of the Christian Church, not for all Christians, but for the Christian Church of Newark. It's the same thing as saying, I got Retro Fitness and 24-Hour Fitness. They're both gyms. The concept is the same. It's just that you can go to this one because you're a member of it, and you can go to this one if you're a member of it. But these people cannot go here. It's as simple as that. It's not based on race, color, national origin, or anything like that. It's based on membership. You're not a member of this club. Let's put it like that. And then there's this one. So before I read this one, it's very important that you guys remember what is federal, what is state. Okay, because the federal exemption, is owner occupied 1 to 4 family. Okay, so this is federal. Allows you to discriminate against the people there are in the other 3 units, right? Or 2 units, or 1 unit, depending on what you have, or even in rooms if you're renting rooms. So if it's owner occupied, it allows you to discriminate, right? But that's federal. If they ask you, and I'm telling you this because when I first took this exam years ago, this question stuck until today because I was stuck on it for 14 minutes. I remember so clearly. 14 minutes stuck with this question. Big mistake. Never get stuck with a question, right? If it's taking too long, if it takes more than 1 minute for you to think about it, skip it. Come back to it later. Last thing, right? Luckily, I passed that exam, but I got stuck for 14. I'm telling you. Why did I get stuck? First of all, because when we did and I think I already mentioned to you guys, when we did the federal chapter on discrimination, and now this one, we're learning that we cannot discriminate or we will lose our license, right? So if anything else, because discrimination should not exist, but if anything else, remember, you could lose your license. There's hefty penalties, potential jail time, and all that good stuff, right? So you might even share a soap with somebody later on. So make sure you don't do that, right? Do not lose your license over discrimination. Now, the question was this. I cannot discriminate, period. And the question was, under state law, when are you allowed to discriminate? And it gives 4 answers. And 2 of the answers were so similar. 2 of the answers were so similar. One of them says, owner-occupied 1 to 4 family. The other one says, owner-occupied duplexes or up and down 2 families. So technically, only in a 2 family, right? And then there's 2 there that clearly you cannot discriminate. But I got stuck. I'm like, you shouldn't discriminate, period. Right? And now, as soon as I got out of there, it just really rattled my brain and I had to figure out what it was. So I went to check the book and sure enough, under state law, owner-occupied 2 family. Owner-occupied 2 family, only. If it's a 3 or more, we cannot discriminate. If it's a single family, we might not even be able to rent rooms. So no, only 2 families is when you can discriminate. If the question was under federal law instead of under state law, right? This is why it's very important that we look out for qualifiers, right? There's a few words that will qualify the rest of the question. So if the question said under federal law, when are you allowed to discriminate and presented the same 4, then the correct answer out of these 2, which will be the only potential correct answers, is the 1 to 4 family. So again, under federal law, when are you allowed to discriminate? On the rental of 1 to 4. Under state law, when are you allowed to discriminate? Two families only. So New Jersey is stronger, right? Stronger than federal law, right? Now, New Jersey cannot go against federal law, right? New Jersey laws are like the icing on the cake. We already have the cake. That's federal law says you cannot discriminate, period. And then Jersey says, well, let's add some icing, let's put some sprinkles, make it even better. That's what Jersey can do. But they cannot cut slices from the cake. Does that make sense? So New Jersey can be stronger, but can never go against federal law. Now, these exceptions, if you guys remember, under federal law, we could, if we're selling the property on our own, like for sale by owner, we could discriminate, right? But if we use a real estate broker, we cannot discriminate. Simple. And look. These exceptions do not apply to race in any situation, thanks to 1866 and Jones versus May. Okay? You guys good so far? Give me a thumbs up if you're good. Great. Awesome. So, prohibitions. Things you cannot do under New Jersey law. So under federal law, we talked about blockbusting as well, which is scaring people into selling their homes because, hey, the Mexicans are coming. Hey, the Portuguese are coming. Hey, the Muslims are coming. Hey, the Christians are coming. Sell now before it's too late. You're going to lose value because they're going to destroy the houses or because they're going to affect the neighborhood or whatever it is. So blockbusting is literally scaring people into selling, right? Now, to prevent that, New Jersey says every broker and obviously agents must keep permanent records of any listing solicitations of 3 or more homeowners in the same block in the same month. So if you're advertising to a particular block and you're trying to hit more than 3 homeowners, you got to keep the records of that advertisement. You have to keep the records. Why? Because they want to make sure you're not skipping a particular person because of race, color, religion, national origin, or whatever it might be. Okay? So they want to make sure you are not blockbusting. Or you got to keep these records for up to 1 year. These ones are common sense. You cannot refuse to sell, rent, or assign or sublease to any of the protected classes as means of discrimination, licensee refusal to offer property or negotiate transactions, falsification of the availability of dwellings, and so on. So these are common sense. We did talk about all these in federal. Again, anything that's refusal as a means of discrimination is prohibited. Any alteration as a means of discrimination is prohibited. Because what's available to me has to be available to you. Right? What's available to you has to be available to me. Simple as that. Okay. Nina, can you repeat the blockbusting portion again? All I said is that if you market to 3 or more homeowners in the same block during the same month, you got to keep records of your advertisement for up to 1 year to make sure if there's a complaint later on, it's just to make sure that when the Real Estate Commission investigates you, right, or even the Division of Civil Rights or Community Affairs investigate you, that you have everything in order and you show that you did not intend to skip a house because of race, religion, color, and national origin. You skipped a house because you're advertising to people that have lived there for 7 years or more, then most likely ready to sell or move somewhere else. Right? That's the reason why you advertise, as an example. Okay? Or you're knocking on doors of expired listings only. Or, we're looking for greenhouses only. Or we're looking for commissioner houses only. Or we're looking for single families or 2 or 3, whatever it is, your advertisement or the reason why you went to solicit listings was never because of race, color, religion, national origin, and so on. Right? So that's why you got to keep records for any advertisement in a single block in a single month for 3 or more homeowners. Good? Now, New Jersey complaints. Before I ask this question, because it's right here, I'm going to ask another question. Under federal law, do you guys remember how long you have to file a complaint? Under federal law, how long do you have to file a complaint? I'll give you the answer in a second. I'll let you guys answer more. I said file a complaint, not a lawsuit. Just putting it out there. File a complaint, not a lawsuit. Nina, you're just throwing numbers out there? You guys are just throwing numbers? Fallon says 180 days. Well, that's the state. What about federal? I'm asking about federal. Under federal law, how long do you have to file a complaint? File a complaint, not a lawsuit. Complaint. Well, 180 days is 6 months. Thank you. Olga says 30 days. All right. Come on, guys. No? All right, cool. So, under federal law, you have 1 year to file a complaint with the Department of Housing and Urban Development. You have 1 year to file a complaint with HUD. You have a whole year, 365 days, 366 in some instances, but to file a complaint with HUD. That's federal law. Okay, that's a complaint. Let me go here. Under Jersey law, you have 180 days, 6 months to file a complaint. But in both instances, if you want to bring a lawsuit, you have 2 years for a lawsuit. Okay? 2 years for a lawsuit. In both of them, 2 years for a lawsuit. And if it's based on race, directly to federal court. Have to. Now, if the offended party is found guilty, the division's director can order a cease and desist payment of damages for pain, humiliation, and other penalties based on the complaints. And also, monetary penalties can go from $10,000 for first offense, $25,000 for second, and $50,000 for third offense. Why they allow you to keep on committing more offenses on discrimination, I have no idea. But $10,000 for first, $25,000 for second, $50,000 for third. All right. So as I usually say, and I'll keep on repeating this, your first transactions of the year, make sure you put them aside for potential lawsuits, because in case you like to discriminate, you're definitely gonna have to pay one of these. So choose which one and go from there. Anti-discrimination poster. If you guys remember, in the federal side of it, when we talk about federal fair housing laws, there's a federal poster that must be displayed. New Jersey also has one. So both posters must be displayed. So if you ever come here to the office, right at the entrance, as you walk in, you might not see it. As you walk in, sometimes people don't, but it's right to your left. When you go out, there's no way not to see it. But it's right there, right at the entrance. You cannot discriminate, right? That poster must be displayed, or you will be punishable by law. State of New Jersey starts at $100 fine and goes up, right? Federal punishment could be a fine, but also it shows immediately that maybe you do discriminate just by not having the poster. Now, you might be the most non-discriminatory person in the world, but not having the poster is the first check mark if somebody puts a complaint against you. All right? So the poster, very important. Now, New Jersey provisions of the New Jersey law against discrimination, rentals in New Jersey are subject to the following regulations. I can reject you for a couple of reasons. One of them is there's too many people for the size of the dwelling, right? So let's give an example. If I see you and it's like it's just a couple and I have a 1-bedroom, I'm going to rent it to you. I got no problem, right? There's 2 of you. There's a bedroom. Got no problem. And notice that I said a couple, right? Because we're going to talk about that in a little bit. I cannot reject same sex if it's available for opposite sex, right? So I said a couple. I didn't say husband and wife, boyfriend and girlfriend. A couple. I don't care who it is. The room's available. Yes, I'll rent it to you. As long as you pay me at the end of the month, I really don't care what you do behind closed doors. That's on you. And nobody should care, right? Unless it's something unlawful, like they're using your apartment to do stuff that they're not supposed to, against public policy. Now, let's say I rent it to a couple and all of a sudden one of you decides to get pregnant. Just saying, one of you says, me, let's do it, right? Can I now reject you because you have a baby? I cannot put any clause in the lease. I cannot put any clause in the lease that says, oh, if a baby's born, you got to get out. No, I cannot put any clause. But what I can do is say, listen, this unit is intended for no more than 2 people according to health and safety regulations. So congratulations on your baby, but I'm going to give you X amount of months for you to leave. I will not be renewing the lease with you guys. You understand? So I cannot put a provision that if you have a baby, lease is done. Cannot put that provision. But if there's more people than what's allowed by state, by a municipality, state, or even federal law, then yes, I can reject it. Obviously, prospective tenants can be rejected because of their credit or income. So when you do a credit application, can I say, well, your credit score is not high enough for what I'm looking for, or you don't make enough money for what I'm looking for? Yeah. I can definitely restrict you on that, credit or income. Again, as I said, if I have 2 members of the same sex, they must be accepted for a 1-bedroom apartment if the same apartment will be available to members of the opposite sex. Otherwise, it's discrimination. Landlords, I think this is common sense. I think nobody should sexually harass anybody, but landlords specifically, in New Jersey law, must not sexually harass a tenant. Hey Jeff, you decided to jump in by yourself? Where's Elena? All right. Service dogs. I can say no pets. There's nothing against saying no pets. Nothing against it. But service dogs must be allowed even in places or dwellings where pets are not allowed. Okay? Landlords may not charge a pet deposit for service dogs, right? But tenants can be charged for any damage caused by the service dog. Elena's at work or you at work, Jeffrey? Because I just had this a student of mine from the evening class goes like, Bruno, can I do morning classes? Because I can do it while I'm at work. I'm like, while at work is really not the best option. I mean, unless you work for yourself, you know? All right, so she is at work, so we'll give her a discount. She's with her principal. That's what it is. All right, so if you have, so this is the final thing here. If we have an apartment building that has 25 or more units, right? Apartment building or community that we built that we're renting out with 25 or more units, 25 plus, okay? Remember 25 because there might be a question. One of the answers says 20 or more, right? That's not the answer. It's 25 or more, all right? So if it consists of 25 or more, then we need to file an annual report with the Division of Civil Rights. Why do we need to file this annual report? Well, it's to say, hey, I'm the owner of this building, and this is how I market, and these are the type of people that I have here. So they want to make sure that you're not racially profiling when you're advertising, and in the application process, you also not racially profiling when picking who to rent in that particular area or in that particular unit or not. So this is very important, especially when we have, let's say, a 25 or more unit. Let's say, usually I give the same example, but let's say it's in a Hispanic community. If the main composition of that community is Hispanic, then most likely, what type of tenants are we going to have in this building? Most likely Hispanics, right? If it's in the middle of the Portuguese area, then most likely we'll have Portuguese people. If it's in the middle of a Haitian area, where it's predominantly Haitians, then most likely we're going to have Haitians there. Now, the idea behind it is, again, that you show to the Division of Civil Rights that your advertisement is broad. It's open to anybody. It just happens to be in an area that's predominantly a particular group of people, and therefore, most likely, those are the ones renting from you. You guys understand? We cannot exclude anybody just because you're in a particular type of area, and that's why they make you every single year file the annual report about how are you advertising, how are you selecting, and what's the composition of your building. All right, next. All right, next we have Mount Laurel 1 and Mount Laurel 2. And yes, you guessed it. Mount Laurel 1 and Mount Laurel 2 is lawsuits. Mount Laurel did not listen the first time, so they had to be sued a second time. Now, for those of you that don't know, Mount Laurel is a rural town in central, almost South Jersey, right? And Mount Laurel, back in the 60s, decided to be an elite town. What is an elite town, or what they want it to be, an elite town? It's like, well, you only make that much money, you don't deserve to live here. We are elite. We are rich people. You cannot come here, right? So the great laws that have been supposedly reversed recently, the great laws of Mount Laurel and Mount Laurel 2 said nobody can be excluded. So in 1975, the judge says, in response to the lawsuit, says all municipalities have to have a zoning that allows enough housing for people with all levels of income, including low and moderate income. The decision barred exclusionary zoning. So exclusionary zoning is when they're trying to exclude the poor people. By the way, who's the poor people? Nowadays, moderate income, you're poor. Sorry. So, low, moderate income, they were excluded from residential areas. Court said, nope, cannot do that. But did Mount Laurel listen? Like I said, they did not. So in 1983, they got sued again. So even though the court has issued a decision in 1975, many municipalities refused to follow it. They said, no, we don't want those poor people here with us, right? It's like we're peasants or something, right? And they're kings and queens, right? Mount Laurel zoned tracts of land that were less than desirable for low and income housing, and another lawsuit was filed in 1983, but now resulted in the citizens losing. So That decision was appealed. The citizens, we're talking about the NACP. That decision was appealed and resulted in the state Supreme Court ruling that every municipality must provide a fair share of regional need for all levels of housing. So they said, I don't care what kind of town you are or pretend to be. You have high income areas, no problem with that. But in your town, there has to be a set aside, at least a 20% set aside for low moderate income. And every single municipality that's developing must have that. The problem is that a lot of municipalities said, well, okay, this is mainly a subsidy. That's what you guys are trying to do. It's mainly a subsidy. So they made an agreement, right? If it's a subsidy to help low moderate income, then we made an agreement. One of the agreements is we're going to transfer the quota obligations to a neighboring town. So now they're giving money. They prefer to give money to a neighboring town and say, hey, here's money for your infrastructure to house these people, right? And that's it. Instead of you living in a particular town, you live in another based on this coalition. Now, another thing that they did is right here. They chose not to grow. What does that mean? You guys remember right here? We're talking about every developing community. Okay? Every developing community must have their fair share. So they have to have that 20% set aside, right? What if they're not developing? Certain towns, like for instance, we have always talk about Alpine, right? Where the cheapest house there is like $3 million, right? Alpine does not allow anybody, let's say I'm a developer, does not allow anybody to go there and say, hey, I bought this piece of land. It's like 100 acres over here. It's not, I'm exaggerating, right? It's like 100 acres, and we're going to divide it and put a bunch of single families, and they're going to be luxury single families, right? And you're probably thinking, well, if they're going to be luxury, they meet the town's guidelines, right? But they do not meet these guidelines. So Alpine rejects the development. And by rejecting the development, they don't have to comply with the 20% set aside. So the only thing that Alpine allows is for you to knock down your house and build a new one. That's it. That's not a major development. Just renovating, knocking down a house, building a new one. All right, so two things are happening regardless of the law and decisions in 1985 is either they're paying your neighboring town or they're not allowing you to progress in that town, right? So you guys are going to notice that. And with that being said, you'd think, for those of you that know Newark, Newark area here where I am, Newark got sued a couple of years ago because of this, believe it or not. Newark, that it's considered low moderate income, got sued because of this. Why? Because there's a lot of new developments here in Newark over the past 10 years. There's a lot of, well, 15 years, but mainly the past 10 years. There's a lot of new developments, and all of them aimed at luxury apartments. So in 2014, if I'm not mistaken, they got sued. The city of Newark got sued and saying that those luxury apartments must have a set aside for low moderate income. So you can build, no problem, but don't forget that it will injure or it will damage the allocation for low moderate income. So you'll see, sometimes you'll see, what do you call it? You see buildings, like right now there's a building here in Newark, luxury, right? And there's one in New York, a case in New York. You see buildings where these lower units, for instance, they're intended for low income, and these are the luxury units. So within the same building, you'll have low income units and then luxury units. What's the difference? Just the type of material that's used, just the type of setup and design that's used, but size sometimes is the same. In certain areas, in certain areas, like in New York, there's a huge lawsuit regarding against a building that was like this. Why? Because that building had the entrance here for low income and the entrance here for high income. So you can now go in through the same door. Not only that, low income allowed you access to this area, the high income, this area. So there's not even a unity there. It's a complete separation or segregation, actually, of low income stays in this floor and has these amenities. High income, no, these people cannot access our floors. So we have our own amenities. So imagine you having a gym for poor and a gym for rich within the same building. Having a laundromat for poor, laundromat for rich within the same building. Completely separate access. So isn't that discrimination in itself? Doesn't that bring the same issues that we were dealing with before? Yes, it does. So a lot of lawsuits against these developments. A lot of lawsuits against these developments. And then you have people saving suburbia. Anyway, Felix says they got sued by a group of people or by one person. Usually it's a group of people, but it takes a few people to complain. The majority of times, the NACP, right? So this association is the one that takes action on behalf of citizens. Okay, so this association says, I heard you, I like what you have to say, and to protect the rights of the people, we need to take action. So they're the ones suing everybody. All right, next thing we got is NAR's Code for Equal Opportunity. You guys remember NAR? What is NAR? Who can tell me what is NAR real quick? NAR, what is NAR? National Association of Realtors. Very good. So most of us are part of NAR, correct? Most of us are part of NAR. One, because we go through our broker, and if your broker is part of NAR, then we will be part of NAR. So that's why we can be called realtors. Notice the registered trademark. You cannot use the term realtor unless you're part of NAR. Okay? Now, what we say here is that NAR created a code for equal opportunity. So they have something that us being part of this membership, we have to follow. There's nothing for us to sign, but we have to understand the guidelines that's presented to us. With NAR, they created also a partnership with HUD. Who remembers what HUD is? Oh, sorry, Felix. I didn't see your message. Fallon, thank you. Yep. Even though the NACP actually helps in different fronts, not just for colored people, they actually help you protect yourself in civil rights. But yes, there's a lot of, like, NACP is great in a lot of fronts. Not just colored people. They care about civil rights. Period. Doesn't matter where you're from, they'll take action. Okay. Housing and urban development. That's right. So we're talking about a partnership between HUD and NAR. Now, NAR, guys, NAR is a private organization. It's like a union. It's we belong to this membership, to this gym membership, let's say, right? It's almost like a union. While HUD is a federal organization. Why would NAR partner up with HUD? Well, NAR is saying, we understand your guidelines, we understand your laws against discrimination, we understand the fair housing guidelines that we have to follow, we understand fully the penalties. So NAR, National Association of Realtors, says we will provide enough training and enough guidelines in implementing these things into our code of ethics as well, right? So the code for equal opportunity is implemented in the code of ethics and makes it not mandatory for you to follow, right? But they will enforce these regulations. In fact, realtors do not need any agreement to comply with the law, but they need to live up to the principles. If you right here, you don't need to sign anything. But if you fail, if you don't follow these guidelines, if you actually ignore the guidelines that are presented by NAR, right, according to HUD regulations, you could actually lose your license. So right here, you can print, or you can just open up and research what is the Fair Housing Declaration that they created. And it's pretty much saying, look, we don't have to sign anything, but we will abide by it, and we will train our brokers. Our brokers will train their salespeople and their broker salespeople and everybody else, right? That's what the agreement says. So HUD, so one of the reasons why they did this as well, one is to avoid complaints of discrimination, and two, remember, we need HUD. We need HUD for several reasons. One of them is FHA. FHA is a division of HUD. So Federal Housing Administration loans, right, are based, they're not available everywhere, but they're mainly based to assist low and moderate income, right? So where does most discrimination happen? Low and moderate income. So NAR says, again, we will help you, HUD, and in exchange, one of the things that we want by providing the safety, this safe environment and equal environment, right? In exchange, we want you guys to keep on sponsoring loans in these areas. So the same way we don't want anybody to discriminate low moderate income, we would like the government to assist with the same people that we're helping protect. And that's where FHA comes from. Okay? Advertising discrimination. Now this is very important. This one's very important for you guys to follow. Advertising discrimination. You cannot advertise whatever you want. You have to be very, very careful. Just yesterday I was reviewing with my partner, we were reviewing a potential listing, and the way it was written, very important. Like, we will not allow the listing to go onto the MLS unless it is reviewed for these issues. Now MLS will say, well, right away we'll give you a red flag and say, hey, change this, change that. But we have to explain to our realtors why you can't do this, why you can't do that. So you got to be very, very careful. In fact, here's some examples. The HUD guidelines, and I'll give you the link in a second. The HUD guidelines clearly states what you can say and cannot say. So right here, for example, you can say great for family, right? Or in-law apartment. These are acceptable, right? But couples only and mature individuals are unacceptable. Any advertisement that indicates preference, limitation, or discrimination based on race, color, national origin, religion, handicap, sex, or familial status is discriminatory, as you guys know, both at federal and state level. So for example, an advertisement that describes a property as close to schools, shoppings, and public parks, it's close. Doesn't discriminate at all, right? It's general, it's liberal, it doesn't discriminate at all, right? However, if one describes the property as close to nightclubs and adult recreation facilities, making this property perfect for singles, it's clearly showing preference for single adults versus families. So we are discriminating based on familial status. This is not appropriate for children, pretty much. Like, let's reject children. Right? And there's a lot more examples here, but definitely go to HUD.gov and search for guidelines. HUD.gov advertisement guidelines. Write that somewhere. Okay, we're gonna have the link here in a little bit as well. All right, as far as leases, this is going to be real quick because all of you should know what a lease is by now. One of the things I want to point out real quick is this. Just like contracts, right? We talked about this yesterday. Just like contracts, a lease must have a statement on the very first page of the lease that says, this is a legally binding lease. They will become final within 3 business days. So what can you do during those 3 business days? What can you do? You can bring it to an attorney that will study. You're not required to have an attorney, as you guys remember, in the state of New Jersey. But you can bring it to an attorney to study and issue notices of disapproval. Now, when do you start counting the time? When does the 3 business days begin? The date of delivery of the signed lease to both parties. Okay, so the 3 business days only start. So I put an offer. I want to rent your unit. Here's the offer. The 3 business days only start when I receive your response in writing. I need to see your signature on that document. Once I receive your signature in that document, boom, the 3 business days start counting, where both of us can bring to our attorneys, and then they go back and forth and issue notice of disapproval of line 101, of line 300 remove, add this to line 1400, whatever it is, right? So this is where they go back and forth. Same as with contracts. All right, we are, on page 460, and we're going to talk real quick about standard lease provisions. Standard lease provisions means we have something called a uniform lease across the United States, and then every state has a little thing about it. So if you guys remember, when we talked about leases before, we talked about this standard lease agreement or uniform lease. So leases, whether oral or written, have provisions that cover both the landlord and the tenant's requirements, so protect both. Having all adults who live in a rental unit sign the lease will make each legally responsible for all or the lease provisions or terms. Now, the lease must include, this is important, the term of the tenancy, whether it's the lease will be from month to month or and self-renew, or have a specific duration or expiration date. Now, this one is called periods to period, right? Does anybody remember? What is the name of this one? That has a specific duration and expiration date. Does anybody remember it? Nina, yes, it applies to both. Yep. Who remembers? So we have leases that run from month to month. As an example, these are periodic or from period to period. And then we have types of leases or leasehold estates that have a specific duration and expiration date. And the answer is, drum roll. Come on, everybody, give me answers. Give me answers. We got two answers. We got 1, 2 answers. Gotta have these. This is the drum roll, by the way. I'm waiting for the answers. What was the other one? Hold on. I need more answers. Come on, drop it here. There you go. This is the favorite. Go ahead, drop some answers. I'm taking points away for those that don't answer. Nidia, you lost all your points. Come on, we only have 2 answers. Last week, guys, you got to remember. Come on. All right, I have too much fun by myself over here. So there's 2 different types of basic estates, leasehold estates. We have the periodic and we have the estate for years. Then we have at will and we have at sufferance. You guys remember this? At will, at sufferance. I allow you to stay there, or you're there without my consent, right? The estate from period to period, Felix, is that month to month that I was just showing you. Right there. That's a month to month. It's from period to period. My question was, what type of leasehold estate has a specific duration and expiration date? Like you check in and check out. Which one is it? And the answer is correct. Estate for years. Estate for years, and estate for years, and estate for years. Yes. So this one, the most complicated one to remember, and that's why I don't get upset at anybody, is the estate for years. If there's a specific duration, specific beginning, and specific end, check in, check out, it's an estate for years. Jeffrey, stop moving. You're making me dizzy. Keeps on moving around. Now, another thing that must be in the lease is how long this lease is going to be for. So if it's a month to month, if it's a 1-year lease, if it's a 6-month lease, how long is it going to be for? How are we going to pay for it? What's the amount? What are the late fees? Right? One thing that I want to show you guys is that in New Jersey, you cannot charge late fees for seniors on Social Security until 5 days have passed. So you have to give at least 5 days. Newark, I'm right on 21. I'm sorry. So what was I saying? So if there's senior citizens, if your tenants are senior citizens that are receiving government pension or Social Security or a government pension, or even railroad retirees, then we cannot charge a late fee. We have to wait at least 5 days before we can charge a late fee. Other than that, when is the rent due? The rent due is at the end of the month, unless, of course, otherwise stated. So the rent is due at the end of the month. That means the first of the month, your bill is due, you got to pay. If you don't pay, I can take you straight to court in the state of New Jersey. I don't have to give you a notice. Go straight to court. If you are a senior citizen, I have to give you 5-day grace period. And that's why most of my contracts, all my lease agreements have the 5-day. Only because I don't want to have to figure out who's on Social Security, who's on the government pension, and who is not. We'll give across the board, everybody, 5 days. On the 6th day, situation is different. Straight to court, right? But at least these 5 days, we got to remember, rent is due at the beginning of the month, and the 5-day grace period is only, for state exam, it's only for senior citizens, unless otherwise stated. The lease must also include what is the security deposit that's being asked for. So state of New Jersey, and this is uniform, but state of New Jersey says every lease, if you're charging security deposit, you must state in the lease what the security deposit is going to be and where it's going to be deposited. In New Jersey, the only amount we can require is 1.5 months as a security deposit. The max that you can charge, is 1.5 months rent in New Jersey. I know some other states you can charge up to 3 months and so on. State of New Jersey max is 1.5 as a security deposit. Now, can I ask 1.5 plus 1 month's rent, like the first month, yes, I can ask for it. But this is the only thing that's considered deposits, and this is already considered payments. You understand? I cannot charge more money as a deposit. I can apply the first month as a payment before you move in. Right? That's what it is. Nina's asking, why isn't it due on the first of the month, but the end? So the payments are usually in arrears. Well, we should be prepaying the month. It's supposed to be doing arrears, but we prepay the month. We're going to live there for a month. So you pay on the first to live there for the whole, whatever, 30 days, 29 days, 31 days, whatever it is. So you're paying to move in. Okay? And then every month you're moving in. Like you're going to occupy that for the next month. That's what it is. Okay? So that's why you got to pay at the beginning. It's due at the end. All right? Next. The deposit can only be used for final repairs, for maintenance, for if you defaulted on your monthly payment, I can take it from the deposit. Okay, so we have to stipulate exactly on the lease what is the intended use of the deposit. Another thing, and I have here in green, is how and when will it be returned? The landlords must return within 30 days of the lease expiration. Now, does this mean I got to give you all your money back? No. What it means is I have to give you the money back. Now, Bruno, what does that mean? What's the difference? The difference is, again, the deposit is used for repairs. So when you leave, I might have to repair. And I have to let you know, State of New Jersey says, I have to let you know exactly what I used your money for. So if you gave me $1,000 and I give you $200 back, what did I use the $800 on? You understand? So I have to itemize everything that I did. And this does not apply for normal wear and tear. This does not apply for normal wear and tear. So, for instance, this wall here behind me has smudges on the wall. That's normal. The usage, right? If you have a leaky faucet, it's normal. It's usage. If you have a carpet and it's faded at the entrance, well, it's normal. People go in and out. It's usage. This is normal wear and tear. Now, if there's holes on the wall, if there's a hole on the wall, that's not normal, right? It was not in the daily activity the hole showed up. No, somebody put a hole there, right? There's a hole on the carpet. Maybe your pets, maybe your kids, maybe you, I don't know. You might have damaged the carpet. That's different. I'll give you another example. My walls here, right now it's just a screen for you guys, but the color of the wall is actually this one. So that's the color of one wall. The other color is the orange that we have from the logo, right? So, and we have a room that's fully green. So we have a green room. Do you think that's normal? Do you think that's how the property was given to us? No. So because we altered the original color, right? The landlord can, that's not normal wear and tear, the landlord can deduct for painting, right? But if you give me off-white and I maintain it off-white and there's just some smudges here and there, can you charge me for painting? Nope. You guys understand? So, itemized deductions does not include normal wear and tear. Now, a few years ago, I was a tenant, and a few years ago, my last tenancy actually, I had $1,850 as a security deposit, and I left. Now, the owner was not in the U.S., and when he came back, September 23rd, I called him up, see how he was doing. We had a great relationship. We were actually friends at the time for the next 5 minutes. So we were great friends for the next 5 minutes of our conversation, talking about, hey, how was your vacation? Welcome back, and this and that. How are things? How are the kids? And vice versa. Until I asked for, where's my deposit? Like, when can I come get it? And that's when things went south, started yelling at me and saying, what do you mean deposit? We're not giving you any money back. I'm like, whoa, 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 whoa. What do you mean you're not giving me money back? Well, there was 3 smoke detectors, and these were high-end smoke detectors with carbon monoxide, whatever. Like they're integrated, so they're very expensive. I'm not giving you money back because those disappeared. And I said, listen. Right, first of all, scale it down. I don't like to argue. Right, I'm not a person to argue. For me to raise my voice is like I'm like at the limit. Right, so I'm not a person to argue. So let's tone it down real quick. First of all, I did the walkthrough with your son. I always talk about this story because it's what landlords think and what the law is totally different, right? So, I said I did the final walkthrough with your son. You were not here, right? Your son is an adult representing you. Did the final walkthrough, and he did not mention anything that was missing. We did a walkthrough. I didn't just leave. We did a walkthrough. Nothing was missing. So now you're telling me that these 3 high-end, best of the best in this house that you have, right? The house is not the best of the best, let's be clear, right? In this best of the, and you had the best of the best smoke detectors and carbon monoxide integrated. Got it. No problem. You don't want to return? You don't want to return. You know what? Like I said, I'm not a person to argue. So I walked away. Got off the phone. Never bother him again. But I went to check the price of the most expensive smoke detectors, most expensive carbon monoxide detectors. And at the time, so you guys know, a pack of 3 combo high-end smoke detectors was $120 at Home Depot. So the 3 that were missing was $120, and he kept $1,850 of my money. You think that's fair, guys? For $120, he did not refund my money. And again, $120, the stuff was there. I never removed anything. But anyway, whatever. Now, I let it go for one reason. I started thinking, I take him to court. I have to spend money in an attorney. I'm going to spend months in court, maybe years. God knows if I'll ever receive my money, right? That was my thought at the time. What I did not know is that failure to give me the deposit back makes the landlord liable for double the amount of the deposit. So, in fact, I could have given it $1,850 to my attorney, and I would have kept my $1,850 that he owed me, plus interest, along the period of time that it would take for him to refund the money. I did not know. All right? So, guys, don't be fooled. Don't be fooled by landlords. And I'm a landlord, so don't, I'm going against myself here, but it's the law. Don't be fooled by landlords. They have to give you the money back within 30 days of expiration of lease, minus itemized deductions. If they don't give you the money back, you can go after double the amount. Okay? And on the same token, guys, if you as a tenant leave, say you're gonna leave, right? But then you wind up staying, the landlord can also charge you double the rent. So there's pros and cons to both sides. Right? Double the amount. Now, the lease must also include name and address where the deposit will be deposited, well, the money will be deposited. The type of account must be for escrow deposits only. And another requirement in the state of New Jersey, and most states have this, you must earn interest rate. Now, why must it be deposited in a separate account, and why must it earn interest rate? Simple. Landlords, it's not your money. It's not your money. It's the tenant's money that we're holding hostage over the next year. We're holding hostage as security deposit. If nothing goes wrong, we give it back to you. But it's your money set aside. If something goes wrong, I keep it. Right? But if nothing goes wrong, I give it back to you. So if I'm holding your money hostage, I need to deposit in a separate account just for this purpose, and it must gain interest because, again, not my money, it's your money, right? And that interest belongs to the tenant, never to you. So pretty much the deposit is like putting, for tenants, is like putting the money in a savings account. That's what it is, the savings. With that being said, tenants, Raise your hand for a second. If you're a tenant, raise your hand. Tenants. Okay. Do you guys know? Keep your hand up if you know where the secure deposit is. 2 people. Out of 6, 2 people. Right? Now, you know where the secure deposit is. You know that you're owed money, right, at the end of the year? Okay, cool. Those of you that don't, ask your landlord. Now here comes the other question. Landlords, raise your hand. Landlords, raise your hand. And don't worry, your faces are not on YouTube, so don't worry. And there's no shame here because a lot of people don't know this stuff. Keep your hand up if you always tell your tenants where the secure deposit is and you have it set aside in a separate account. We have one landlord. All right. Ahmed says bank updates them. There you go. Whatever works. But it sucks because here's the thing. Most homeowners or landlords, they do not go through a course on how to be a landlord. So a lot of you guys do not know these rules, right? Oh, you use Columbia Bank? Okay. They do everything for you, even better. Okay. So, but most people do not know this stuff. Unless you're like a property manager where you go through these rules, right? And you learn what you have to do. Unless you're a property manager, most landlords have no idea. And guess what? Tenants don't know either. So because tenants don't know and landlords don't know, people live their lives like this, right? In fact, in New Jersey, it happens a lot, and I'm sure in other states as well. It happens a lot that tenants ask me, hey, Bruno, since I'm leaving, can you just apply the secure deposits to the last month's rent? Like, no. I'll give it to you at the end. I'll give it to you at the end when you leave. But secure deposit cannot be used for last month's rent. Secure deposits for final repairs. So once you leave, oh, but Bruno, but the house is great. You see that there's no damage. Yeah. When you take the furniture out, I'll see. Right? And by the way, so far I haven't had complaints from tenants. So far I have referrals. When people leave, they refer more people to come to my property. So that is, see what I'm trying to say? So I have a good relationship. What I'm trying to explain to you guys is that we're very clear, right? My office manager is very clear of talking to them what the secure deposit is for, right? It circles even. When one of the things that he used to do is circle certain details of the lease as he's going over the lease with the tenants, right? So this is what's intended for, right? Because we have certain basements rented as well. They're rented for storage purposes only. So you're just storing this stuff there, and he circles in the lease. So if you ever use the basement for any other reason, as an example, right? We circled. You got your copy, I got my copy. That's what it is for. It's just for storage purposes, right? Rentals. There's one person only, or there's 2 people only. Now there's 10 people. Hey, we circled. It was just for this. So make sure people clearly understand, even though you don't have to, the lease is the lease, it's done, it's in your hands. You signed it, I signed it, we're all adults, competent parties. But make sure you go the extra step and explain to them what things are intended for, right? Very, very important. Attorney fees must be there as well. If a tenant eviction or court proceeding is required, who's going to be liable for attorney fees? Of course, tenants are. And then other rules. What are you allowed to do in the unit? What utilities you'll have to pay, like trash disposal, etc. And in the state of New Jersey, if the landlord furnishes heat, then I must maintain the room temperatures to 68 degrees from 6 a.m. to 11 p.m. and 65 degrees from 11 to 6 a.m. between October 1st and May 1st. So it can never be less than 68 degrees during the day and never less than 65 degrees at night. As far as repairs and maintenance. As far as repairs and maintenance, New Jersey recognizes the tenant's right to repair and deduct. So New Jersey says, the landlord, let's start with this lower one before we go to this one. New Jersey says that the landlord's supposed to provide the property to you with the implied warranty of habitability. What does that mean? It means that it's livable. It means that it's safe, right? When I say livable, it's not like, oh, it has four walls, there's a ceiling, we're good. No, no, no. Livable conditions. You have water, you have electricity. Like you can have electricity, you can have the gas. There's the four walls. There's no leaks. There's no damage. There's no danger to your life, health, and safety. Okay, New Jersey says there could be no danger to your life, health, and safety. Okay, that's the implied warranty. If anything happens that could endanger your life, health, and safety, then the landlord must make the needed repairs within a reasonable time. And failure to do so allows the tenant to repair and deduct. Allows the tenant to withhold rent. New Jersey allows you to withhold the rent. Obviously, consult with a lawyer before you do these things, but New Jersey does allow you to repair and deduct. So, landlord, you're taking too long. Yeah, I'm fixing it. Now, can this be anything? Can it be like, oh, it's a light bulb. The landlord doesn't come in to change a light bulb. I'm going to change the light bulb and I'm going to deduct from the rent. That's a little ridiculous. But if it's a leak, right? If it's a toilet that's not working, if it's in the middle of winter, there's no heat. Yeah, I'm going to fix it right away and deduct from the rent. Does that make sense? So if it's something that could endanger, remember this. If it could endanger life, health, or safety, New Jersey allows you to repair and deduct. Because again, the landlord's responsible for implied warranty of habitability. All right, the lease has to include also if there's pets or not. Remember, you're allowed to exclude people. You're allowed to exclude people because that unit is yours. But, for instance, in my leases, every 6 months, I inspect the property, or somebody from my office inspects the property every 6 months. Can I just go in? No. So there has to be, in the lease, it has to state under what conditions I can go in. So emergencies, right? I don't have to call you for that. Well, I should call you first. But if it's an emergency, if there's a fire or something like that, I can go in. Or how much notice do I need to give you before going in? So as a landlord, usually I say at least 24-hour notice. We usually give more than that, but at least 24-hour notice, we're going to go there and see the property. Okay? Tenant behavior. So there has to be rules as well as of what you can and cannot do. Right? So if you have disruptive behavior, illegal activities, property destruction, or anything like that, then I'm able to kick you out. These are reasons for eviction. And you guys already know the disclosures for lead-based paint. If it's in the flood zone, I have to let you know as well. Landlords, tenants' rights, and responsibilities. This is the truth in renting. Disclosure, truth in renting. That shows the tenants' rights and responsibilities. Name and address of property owners, managers, superintendents, and mortgage holders. And if there's a renewal or not. Okay. And here you go. Truth in renting. Make sure you guys remember this one. Truth in renting. Because the truth in renting is an annual updated statement that must be provided to every single tenant. And you have to post it in the property as well. Every single tenant must know everything that's in this chapter as far as leases and discrimination as well. Okay? So that's what the truth in renting is. You must also be posted in the building. And failure to do so is a penalty of up to $100 per offense. So you guys can print it. It's right here. You can print it, give it to your tenants, and post it in the property as well. Now, quick question. Just a quick question. What if you didn't post it yet? What if you didn't provide it yet? Well, one of the ways to reduce liability, if you guys remember from agency, from chapter 11, one of the ways to reduce liability is as soon as you find out that there's an issue, you present a solution for that issue, or you disclose that issue. So now that you guys know, can you say, oh, I didn't know? No way. You could never say, no, you didn't know, but now even less. You are required as landlords to provide this to every tenant. Thumbs up? Are we good? Great. All right. So the next thing we have is the ADA, which is Americans with Disability Act. ADA applies to commercial only. Commercial properties only. Americans with Disability Act applies to commercial properties only. As a residential landlord, I don't have to alter the building to meet somebody that has disabilities. Can I alter the building if I want to? Yes. In commercial properties, I might be forced to alter the building. Now, I'll explain what altering the building means in a second. Just remember, one of the things you need to remember, the ADA is for commercial properties only. All right. So, Title 3 of the ADA, because we covered this before in property management. Title 3 of the ADA prohibits discrimination in public accommodations against people with disabilities. Public accommodations include owned or leased facilities such as hotels, stores, offices, common elements of commercial buildings, and so on. Owners and property managers must comply with the Act by providing equal access to their facility to those with disabilities. This may mean that you need to make changes to the buildings, for instance, to add ramps, widen doorway openings, modify public restrooms, ensure elevators work properly, and so on. However, owners are not required, we covered this in property management, chapter 24. Owners are not required to make extensive, costly structural changes because ADA allows for reasonable accommodations. So do I have to restructure the whole building? No, but if it was something that was easy, something that was financially feasible, right? You could have done it already. Like, for instance, it doesn't say here, but for instance, auditory signals in the elevators, braille markings on the buttons on the elevator, right? Ramping, as it says here, widening doorways. These are simple things to do, right? They don't require you to build a brand new building, right? They don't require to knock down half of your building. It's simple stuff. So ADA is for Americans with Disability Act, applies to commercial properties only, right? And requires you to replace some stuff or change some stuff in your building as long as it's reasonably achievable. And this equals easy and low cost. Okay? Now, low cost varies. It's not like, oh, it has to be less than $10. No. But again, goes for whatever is reasonable. It's reasonably easy and reasonably low cost for the type of building that we have. Okay? So ADA, these are the things you need to remember if there's ever a question. Do we need to restructure the building to put an elevator? No. Ramps, yes. Handicap, that's most likely the question in the state exam. You need, school exam or state exam. You need to make sure, if you have a parking lot, make sure you reserve 1 or 2 spaces for a handicap. How easy is that? You see what I'm trying to say? It's just literally marking the floor. Why didn't you do it, right? So that's what it says. As far as rent control, there's no state law regarding rent control. About 1/4 of the municipalities in New Jersey have their own rent control. So state says, hey, municipality, you deal with it. That's pretty much what it is. State of New Jersey says reasonable increases are okay. So if you feel like that increase is too much, can you bring the landlord to court? Sure. But then the judge will determine what is reasonable, what is not. About 1/4, as I was saying, 1/4 of the municipalities in the state of New Jersey, about 1/4 of them have their own rent control. So you need to know, whatever market it is that you're in, you need to know what their rent control guidelines are. So somebody asked me 2 days ago, hey Bruno, in Elizabeth, this is the property, can they do this, can they do that? I said, oh, hold on. Is that your market? If so, you should know. I know in Newark, I cannot tell you Elizabeth. Now, the point that I was trying to make here is there's too many municipalities for you to know every single code in every single municipality. The point was, you got to do a quick research or quick call sometimes to figure out what we can and cannot do. Now, I happen to know the answer, and I gave him a part of the answer, and I said the rest of your question needs to be addressed to the Department of Community Affairs. So you can go online, most of them have that regulation online, or you can call them directly and ask that question. You understand? But every municipality has their own rules. There's no uniformity, as I said right here. There's no state law, but some municipalities have rent control. Okay? So you guys need to know each municipality, what is their rent control. And by the way, rent control changes. If it's a single family, if it's a two-family, 3, 4, forget it. From 4 or more, now it depends on the type of unit and structure and bedrooms and a bunch of other things in certain municipalities, right? It's just ridiculous. So 1, 2, and 3 are easy to remember. 4 or more, they have different rules for 4 or more. Okay. Lease termination. This one's simple. Leases that include an expiration date expire on that date, obviously. And the lease that can also be terminated if the landlord or the tenant breaches the terms. So if anybody breaches, terminates the lease. A party who wishes to terminate the lease must provide notice based on the type of leasehold. If it's an estate for years, you guys already know, estate for years, no notice is required. If it's a tenancy at will, so it's indefinite period of time by now, at least 3 months notice. If it's a year to year, 3 months notice, month to month, 1 month, 1 week, or 90 day. Now, one thing I want to point out that doesn't say here is that it says 1 month. It says 3 months. Does it say 30 days? Does it say 30 days? It does not. Okay? So this 1 month thing here, 1 month is before rent is due. Okay, so this 1 month thing is before the rent is due. So if the rent is due on the 5th, the previous 5th, you got to give that notice. And this eliminates the whole thing of the 28 days, the 30 days, or the 31 days, right? So it's not a 30-day notice, it's 1 month before the rent is due. So remember that for state exam and school exam, 1 month before the rent is due. That's the notices we have to give. If you're leaving, or if I ask you to leave, 1 month before the rent is due. Okay. Next we have is the New Jersey Anti-Eviction Act. New Jersey Anti-Eviction Act. The New Jersey Anti-Eviction Act was signed into law in 1974 and requires reasonable grounds for eviction. So you cannot evict just because. There has to be reasonable grounds. Okay. Another thing that was implemented is that for you to evict somebody, it has to be through court order. So you cannot just change the locks. You cannot just evict a tenant because, right? You have to go to court. And some of the reasons for eviction are disorderly conduct, breaking the rules of the lease, right? I need to move into the unit, so I have to give you at least 60 days notice, right? Shutting down or demolishing the building, so 3 months notice. And if I want to change the building from residential to commercial, I got to give you at least a year and a half notice. The landlord may not evict the tenant except for one of the following good causes. They did not pay the rent disorderly conduct, destruction, violation of the rules. We already went over these. Illegal activities, violation of, failure to pay the rent increase, landlord housing or health code violations, landlord retiring the building, failure to accept lease changes, consistent late payments, and so on. So if you're always late, can I evict you? Yes. All right. A lot of people don't know about that one, but if you're always late, then I can evict you. Oh, but I'm always late, but I pay. Yes, but you're not consistent, so it affects me in my life. If it was a one-time deal, no problem. But if it's a consistent thing, I might be able to evict you. Again, landlord to live in the unit. Loss of tenant's job tied to the rental unit, like you're a superintendent, you no longer work with us, so get out. Tenant's drug activity, theft, assault, or conviction, or threats to the landlord. These are reasons for eviction. An illegal eviction is a criminal offense. So in New Jersey, self-help evictions by landlords with no court order are illegal. Locking out the tenant, shutting off utilities, threatening the tenant, putting the tenant's property outside the unit, or holding the tenant's property to obtain the rent are illegal. Unless you're a Portuguese landlord, then it's okay. But everything else, 100% illegal. You guys cannot do these things without going to court. Very important. You guys did not know the Portuguese were above the law? They are. Like, whatever I say goes. I'll tell you, I have, you guys are laughing. You probably have either Portuguese tenants or landlords, or you know somebody that's like that. But the funniest thing is, and I dealt with that years ago. I just don't listen to it anymore. But the funniest thing is, especially the older Portuguese, right, that have been here established for years, right? They go like, it's my house. Tenant does not pay, I change the locks, period. And if they show up, they see the door closed and they don't change the locks and all that, and they don't call me to pay, next day, everything is on the street. That's it. Oh, but that's against the law. Have the cop call me. Have the cops call me. Just like that. Like, they're not afraid. They're Portuguese people, they're not afraid. I don't know. Have the cops call me. Take me to court, whatever. Anyway. To clarify, I'm Portuguese. I'm talking about my own people. So it's not discrimination when you tell the truth about your own people. Somebody's going to hit me right now. Anyway, if a tenant remains in a rental unit after notifying the intent to vacate, I already told you this, you might be responsible for double the rent. If you said you're going to leave and you're still here, double the rent. Okay? We are done. You guys have any questions? Questions, throw questions. Remember the rules. If you have a question, put a question mark. And Nina, because of you, I implemented this with the evening class. If you want to speak, like in case you have like 100 questions, if you want to speak, you put a question mark and say, write mic in front of it. I'll give you the mic. I'm constantly evolving, so I'm learning with you guys, you know, and the needs. All right. Ahmed says, increase in rent year over year, does it have to be stated in the contract? Yes. So if the rent, like for instance, here where we are, there's a 3% increase of the rent every year. It's already stated. 3% increase every single year. The first year was exempted, and the first 2 years are exempted, and they're on 3% every year. It's commercial. Yeah, commercial, there's no rent control rules. It's like commercial is a different ballgame. But yeah. But anyway, 3% could sound like it's a lot, but in $1,000, how much is 3%? That's as much as you can increase, $30. Some towns under rent control, which your lease, make sure it's according to, at least make a statement that it's according to whatever the local law is. In certain towns, it's 3.5%, or CLI, which is the cost of living index, whichever is less. So if this year CLI, so cost of living, went to 4%, right? Then this is the max that you can charge, right? If CLI next year is at 2.8, then this is the max you can charge. So again, rent control in every municipality is different. Linden has 3.5% or CLI, whichever is less. And they also put a cap of no more than $50 increase in certain types of properties. So this is what I'm saying. I mean, you have to figure out each municipality what is allowed or not allowed as far as rent control. Now, if it's a Section 8 type of property, all Section 8s have rent control. So there's always a max that you can charge. Even if your municipality does not have rent control, Section 8 or TRAs, temporary residential assistance, renter assistance, have rent control. Okay? Awesome. All right, guys. So considering the time, and again, I apologize for the delays. Considering the time, there's no way to get into a second chapter. But again, tomorrow is just math. So we'll do chapter 30 tomorrow. That's the first thing. And then we'll jump into math in the second half of the first session. All right? You guys have any questions that you'd like to address before I end today's session? No? No? Oh, she just... I even adjusted the mic so it shuts off when I don't speak, so you guys don't hear the background. But sometimes sirens just come right through. Nina, what should we focus on for the exam? The answer is everything. Everything. But I can tell you that the majority of the questions are on professional activities, brokerage activities, and agency, chapter 11. Those are the majority of the questions in the school and state exam. So I mimic the school exam as much as I can to the state in terms of amount of questions per group, right? So if it's agency, there's 22 questions in the state exam. So I have 22 questions in the school exam. If it's financing, there's, I think, 11 questions in the state exam. So I have 11 questions in the school exam. So I try to mimic the state exam as much as possible, right? So, but yeah, you still need to know appraisals, you need to know financing. Agency is very, very heavy, as I just said. About 30% of the exam is agency and brokerage activities. About 30% of the exam. So heavy. Am I saying just focus on that? No, obviously not. But put extra focus, and I keep on saying that in those chapters. When I get to those chapters, I always like enforce how many times you're going to have these questions in the state exam, so, or scenarios. So focus on those. Okay? All right? So if there's no other questions, guys, I wish you an amazing rest of your day. And I'll see you tomorrow at 10 a.m. for the morning class. And I'll see you tonight at 5:30 for the evening class. All right, guys. Have a good one.